Hey everyone, thank you so much for joining in. Are you also an artist or a creator? You got a trademark? Great. Got a patent? Amazing. Got a copyright also? Amazing. But what if someone still misuses your trademark, copyright, or any other intellectual property? The situation is known as the infringement of intellectual property. Violation or infringement is the mainly common type of intellectual property dispute in the case of trademarks. In order to deal with such a violation, taking help from IP specialists will be very helpful. Trademark infringement is all about unauthorized usage of the trademark or service by an unauthorized individual which is identical or deceptively similar to an already existing and registered trademark. The word deceptively similar implies that when a customer looks at the mark, it will get confused with the other registered trademarks. The provisions of trademark infringement primarily center on three principal objectives of any individual who is using the registered mark. However, it is not registered user of the trademark. And what are these primary objectives? Right here. Having a false intention of taking unnecessary advantage, damaging the originality and the reputation of the registered trademark, the purpose of trademark usage despite having the knowledge of such usage is illegal. All the registered trademarks are safeguarded under the Trademark Act 1999. This act provides for the provision dealing with registration, protection and fines of the trademark infringement in India. Now, what can we do if trademark infringement happens? What are different remedies? Now, what can we do if there is a trademark infringement? What are different remedies that we can follow? Criminal remedy. The remedies uttered by the court to the trademark infringer in the case of criminal proceedings are as follows. With imprisonment for a period which must not be less than 6 months, can be extended to 3 years. With a penalty that should not be less than rupees 50,000 and which can be increased up to rupees 2 lakhs. In case of the civil remedy, the trademark infringement, the remedies are as follows. Account of profits. Harms in the form of profits gained from the goods or services by infringement will be given. Damages or harm in the form of compensation will be given to the registered trademark owner. If there is a destruction of goods and services, it can also be ordered for the trademark infringement is done. The court can pass interlocutory injunction to discover documents restraining the defendant from placing any assets that can cause a severe effect on the plaintiff and preserve infringing products and services. An injunction is an order which will limit the use of the infringing trademark. Proceedings cost. The court can order the defendant to tolerate the cost of the proceedings of the appellant. Now, let's understand what is the procedure if you want to obtain any of these remedies of the trademark infringement. Procedure under a criminal law. An FIR can be filed in the section 154 of the Criminal Procedure Code, that is also known as CRPC. In case the police office declines to file an FIR, the individual can file a complaint in section 156(3) of the CRPC before the magistrate. Once the FIR is registered or any order is passed by magistrate, an investigation will be commenced and it will be conducted by the police officer. The benefit of the criminal remedy in case of infringement is that the victim can begin a proceeding against any unknown individual also. Now, sometimes the identity of manufacturers and distributors is not identified to the victim, and this works as a hurdle in filing a criminal complaint against the trademark infringer. Procedure under civil law. A case under section 134 of the Trademark Act can be filed in the district court in case of trademark infringement. The jurisdiction of the district court shall be there where the head office of the plaintiff is located or the place where the cause of the action has arisen. For suit under section 134 of the Act, section 20 of CPC doesn't apply to the filing of such a lawsuit. The court, if thinks appropriate, can pass the following order. An injection under Order XXX1X of CPC and under Section 36 to 42 of the Specific Relief Act will be restraining the extra use of the infringing trademark, damaging of accounts of profits, devastation or erasure of infringing labels. The process of trademark registration is lengthy and very time consuming. So if you are someone who wants to pursue that and need help, we right here have experienced professionals to assist you in enabling the trademark registration. Our IP specialist will guide you with the process of trademark registration and will help you deal with the infringement and other IP related disputes. And therefore, they will ensure the successful and timely completion of your work. Thank you so much for watching this video. And if you feel that there is something else that you need to ask and you need to know, do share with us in the comment box so we can help you with that. Until then, take care. Bye-bye.